Good evening, everyone. Okay, great. It's so wonderful to see so many of you here tonight and online. We have a really robust audience, and both here in person and online. I'm Julie Mostov. I'm the Dean of Liberal Studies at NYU, and I'm very pleased to welcome you here tonight. We are so fortunate to be partnering this evening with the Office of Global Inclusion and Strategic Initiatives and the Birnbaum Women's Leadership Center, and of course, a number of other partners around the university. This is our annual Global Lecture Series. And we are really proud to be able to bring internationally and nationally renowned speakers to draw on some of the really critical issues of our time that highlight the global, interdisciplinary, and engaged education and scholarship that we are so proud of in liberal studies. So this evening, you can imagine how delighted I am to be able to partner with Dr. Lisa Coleman from the Office of Global Inclusion and with the Birnbaum Center. I'm also thrilled to be having here tonight Professor Melissa Murray from our law school, and in conversation with our own GLS alumna, Julianne McShane. That's pretty exciting, I think, to be able to bring the two together to talk about topics that personally I feel like I have been engaged with and championing most of my life. And I want to say my adult life, but not just my adult life. Even as a teenager, I realized how critical our reproductive rights were to us as women and to members of our society, to all people who live in our global community. Many of you know that I have talked about this in class when we think about issues of rampant ethno-nationalism, extremism, populism, which undermines people's abilities to move, violations of human rights. How many of those are associated with the way in which we look at the roles of women and issues around demographics and reproductive rights? So that is another reason why I think it is so compelling, so important that we have this discussion here tonight. So I'm going to hand over the mic to my partner in so many different important discussions and undertakings, Dr. Lisa Coleman, the Senior VP for Office of Global Inclusion and Strategic Initiatives. Lisa.
Thank you so much, Dean Mostov. It's such a pleasure to be in partnership with you all the time. And as was said, my name is Lisa Coleman, and I use she and her pronouns. I know that I'm going to describe myself because there might be some people who cannot are sight impaired. So I am an African-American woman. I have curly hair, and I'm about 5'6" tall. I have on black clothes always, and I have rings on. And I'm the Senior Vice President, as was mentioned, of Global Inclusion and Strategic Innovation. It's my pleasure to also welcome you to the first NYU Women Lead event of the academic year. We've partnered on NYU Women Lead, I think now for about 3 years, if that's right, Julie? So, and it's a global leadership accelerator that celebrates and amplifies the prolific work of women trailblazers, past and present, and centering intersectional gender equity and innovative leadership. I'd also just, before I move on, like to acknowledge a couple of things that NYU, both as a global institution and here in New York City, is located on the unceded lands and was founded by the exclusion of many across our indigenous peoples globally, as well as other historically marginalized communities whose labor have contributed to NYU, those who are known and unknown to us. We at NYU continue to address these legacies. And if you could just join me in 5 seconds of silence and gratitude and recognition for those who've come before us, laid the groundwork, and for, of course, current and future generations. Thank you for that silence and recognition. Again, I want to give a special thank you to Dean Mostoff and her entire team and the exemplary service to uplifting women leaders across our community and beyond. We've been champions of this work as with Dr. Murray and others for a while. We won't say how long, but we can just say it's been a while. It wasn't yesterday. A big thanks to Dee Simmons, Gabrielle Muss, and of all of our partners in liberal studies. Many thanks to, of course, the Birnbaum Women's Leadership Center, and of course, the Women's Leadership Presidential Forum. I have to, of course, thank my amazing team in global inclusion, and a particular thank you to Vice President, Senior Associate Vice President, Dr. Karen Jackson Weaver, and of course, Autumn Rain, Lucero, and Lady who are here as well. Thank you so much. And of course, to the liberal studies faculty, and of course, to Professor Murray herself. Thank you so much for being with us today and for your generosity in continuing to be in conversation with us about a number of issues. And of course, as Dean Mostoff mentioned, Julianne McShane, thank you for being here with us today. I'm going to just read a little bit, as I was told to do. Is a former adjunct, I always do what I'm told to do, former adjunct professor at NYU's Arthur L. Carter Journalism Institute, and a news and engagement writer for nonprofit and investigative news outlet Mother Jones, where she contributes to news coverage and reports on gender and inequity. She holds a master's degree in multidisciplinary gender studies from the University of Cambridge, and has reported for NBC News and the New York Times and the Washington Post, among other publications. And she has covered the ripple effects of abortion restrictions through a national fellowship awarded through USC's Center for Health and Journalism. So thank you for returning and being with us today. I'm going to turn this over to you and to the conversation with Professor Murray. And thank you to all of you for being here for this important conversation, as Dean Mostoff mentioned.
Thank you for that intro. I'm the last person standing between you all and Melissa Murray. I know these intros can get burdensome, so bear with me. We're almost through. Thank you, Dean Mostoff, also for the invitation to be here tonight, and to everyone at Liberal Studies who worked so hard to make this event happen. When I was asked to be part of this globally focused conversation a couple months ago, I was, of course, honored and excited to return to NYU, but I was also a bit intimidated because, like many US journalists who cover abortion access and reproductive rights, most of my coverage has focused on how these issues manifest in the US specifically. And since the Supreme Court handed down the decision in Dobbs versus Jackson Women's Health Organization that overruled both Roe versus Wade and Planned Parenthood versus Casey last year, there have been a lot of stories to tell about the ever increasing restrictions on abortion nationwide, about the practical limits of so-called exceptions to state abortion bans, about the success of state ballot measures, about what role abortion has to play in next year's elections, and so much more. So I figured that preparing for this conversation about abortion and reproductive rights in a global context would require that I spend some time studying up on how these issues are manifesting elsewhere. But it turned out that that wasn't really necessary because this information basically came to me in the form of frequent headlines that show just how relevant these issues are globally and how urgently they're playing out. So just a few examples that we'll discuss more tonight. Argentina just elected a new far-right president who campaigned on a promise to hold a referendum to repeal abortion access. France is moving to become the first country to explicitly enshrine abortion rights in its constitution in direct response to what's happening here. And just last week, an investigation published by the New York Times found that disabled women are still being forcibly sterilized throughout Europe, despite bans that are in place. History shows that reproductive rights activists have also long worked across borders to further their goals. Activists in the US and Mexico, for example, have long relied on each other for abortion access at different points in time. And right now, after Mexico's Supreme Court decriminalized abortion in September, it's Mexican activists who are helping Americans, especially those in Texas, access abortion by sending them abortion pills by mail and by welcoming them once they cross the border. So I think it's to our detriment that these conversations in the US tend to be so nationalist in nature, and it's to our benefit that we understand them from the global and interdisciplinary perspectives that events like this encourage. And luckily, we have an expert here tonight to help us make sense of this moment and what comes next. Melissa Murray is the Frederick I. and Grace Stokes Professor of Law here at NYU and the Faculty Director of the Birnbaum Women's Leadership Center at NYU Law. Her award-winning research focuses on the legal regulation of intimate life, and she's a leading expert in constitutional law, family law, and reproductive rights and justice. Her scholarly publications have appeared in a long list of prestigious journals, including the Harvard Law Review, the Columbia Law Review, and the Yale Law Journal. And her op-eds have appeared in the pages of the New York Times and the Washington Post. Somehow, she also finds time to be a regular contributor to MSNBC and to co-host Strict Scrutiny, a weekly podcast with Crooked Media, on which she and other legal scholars break down the Supreme Court's cases, culture, and personalities. And we know there's a lot of personality on that court, so that's not easy. I'm thrilled to be in conversation with her tonight. Please welcome Professor Melissa Murray. Hello.
I think by personality, you mean ethical lapses.
Ethical lapses, personality. Yes. I'm sure they would prefer that we say personality.
Something like that.
But that's probably why we should say ethical lapse. So thank you so much for being here. And as I said earlier, I don't know how you sleep with the bio that I just read. You have done so much, not only in your scholarship, but also in your public facing work to help people understand the significance of this decision, especially, and many others over the past year. So we're very excited for you to be here. One of the things that I found really interesting when I was doing the deep dive on your work over the last few weeks is that you have long recognized what a lot of people are just starting to recognize after the Dobbs decision, which is that abortion rights or attacks on abortion rights can foreshadow attacks on other intimate rights like contraception, interracial marriage, LGBTQ rights. So we have a lot to talk about. But before we do, we can start with the main issue that we're here to discuss tonight, which is reproductive rights. And so I have this slide from this graphic from the Center for Reproductive Rights that I was pretty struck by because it shows just how out of step we are with the rest of the world. So it shows, this is from last year, so I don't know if, it should be nearly up to date. But yeah, okay, she says it is, so we'll go with that. So there's been 4 countries, including the US, that have removed legal grounds for abortion since 1994, and 59 that have liberalized their laws, which is pretty striking. But this doesn't tell the whole story, actually, because it doesn't show the burgeoning backlash that is at play from these newly elected far-right leaders, and that the US was actually involved in leading even prior to the Dobbs decision. In 2020, the Trump administration led a group of more than 30 countries in signing the Geneva Consensus, which was a non-binding international anti-abortion declaration. We were joined by fellow bastions of democracy such as Saudi Arabia, Brazil, Poland, Hungary. Foreign policy called it symbolic of a growing backlash to an otherwise global trend toward broadening reproductive rights. So I guess the foundational question is, why is restricting reproductive rights a key tool in the playbook of these authoritarian and far-right leaders, especially because we know that restricting abortion in the legal landscape doesn't actually stop abortions from happening.
So first, thank you so much for having me, Dean Mostoff. Thank you for this warm welcome, Dr. Coleman. Thank you for assembling all of these terrific smiling faces of very few law students because they have exams, and that seems exactly right, although I see Kyle in the back. And thank you, Julianne, for that terrific introduction and for setting up the issue so spectacularly well. Why does the assault on women's rights go hand in hand with rising authoritarianism? I think we know, right? When women have rights, when they are able to leave the house, when they are able to make decisions for themselves, and they are able to participate in public life, and other people find that their authority is somehow more limited when that happens. And I'm not the first person to recognize this. Another fabulous NYU professor, Ruth Ben-Ghiat, has written extensively about authoritarianism and its associations with masculinity and notions of manhood. And that's not surprising, right? And it goes back in time. Like, this isn't the first time we have seen the assault on women's rights and rising authoritarianism. If you go back to Nazi Germany, the Nazis emphasized this idea of Kinder, Kirche, Küche, which is children, church, and kitchen, right? And this could basically encapsulate the entire universe of women's domain: motherhood, fidelity to the church and traditional religious morals, and then being bound to the home, the role in the home. And indeed, during the Third Reich, women's role in society, both their social and political role, was wrapped up in wifehood and motherhood, raising the next generation of individuals for the Reich, for the Führerland. And so women and this whole idea of compulsory motherhood, nation building motherhood, is very much part and parcel of what we understand of authoritarianism. And, we are seeing this now. I mean, this is not a remnant of the past. We've seen in China that there have been assaults on women's rights in terms of bodily autonomy, demands to carry pregnancy to term, demands to terminate pregnancies depending on the needs of the state. In some countries, there have been demands for women to wear the hijab, regardless of whether they want to or not, and to maintain public personas that require literally shrouding themselves in public life. And we have seen retractions on domestic violence in places like Russia, for example. All of this, I think, goes hand in hand with creeping authoritarianism. So it's not a surprise to me that we saw in Argentina the election of a far-right leader. That is a country that over the last couple of years has seen a lot of activity, along with other Latin American countries, in the realm of liberalizing abortion policy, the green scarf movement in Latin America. And this is part of the backlash to that. We can understand the rise of Donald Trump, and maybe even his rise again, as part of the backlash to a changing demographic profile in this country, also a changing leadership profile in this country. If you recall the events of January 6th, it wasn't simply that individuals assaulted the Capitol in an effort to overturn the results of a validly conducted election. When they invaded the Capitol, there were calls to get Nancy Pelosi, to find AOC, to get Kamala Harris. And it's not surprising that a week after that happened, on January 13th, Nancy Pelosi, as the first woman to serve as Speaker of the House, signed the articles of impeachment, the second set of articles of impeachment against Donald Trump. And it's not a surprise that a week after that, on January 20th, we saw Kamala Harris sworn in by Sonia Sotomayor as the first woman to serve as vice president and the first woman of color to do so. Right? We have a changing leadership model in this country. And for everyone, that can be a source of pride, but for some, it can be a source of profound anxiety and a real desire to turn back the clock, to make America great again, an America that I recognize. And so we should understand all of these things as part and parcel. And so Dobbs was not a surprise to me. I said Dobbs is going to happen back in 2018, and everyone told me I was a shrieking harpy. I was correct. And again, I take no pride in being correct. This is not like a fight with my husband where I'm like, I was right.
But
like-
she does have the receipts.
I do. I mean, yeah, like this was predictable and indeed was predicted. And I think we are on the precipice of predicting again more of the same. And the question is, are we going to allow it to happen on our watch?
What is your prediction for if we have a Republican candidate in office? How will they try, at this point, I think most of us agree it would probably be Donald Trump. But how do you think that they would move to further restrict abortion rights?
So if Donald Trump is indeed the Republican nominee, and all signs point to that, I think it is very likely his running mate is Nikki Haley. I think that anesthetizes some of the outrage that American women have had toward conservatives over the last 2 years because of the Dobbs decision. It sort of mutes it to some degree. I think it gets some individuals who are perhaps concerned about Joe Biden's age, which is honestly not that different from Donald Trump's.
3 years, right?
And maybe some who I think are a little more anxious about the prospect of a woman of color being a heartbeat away from the presidency. It gives them an out, and one that can sound in the register of a progressive ethos, like a woman as vice president. I think there will be more efforts to continue to stalk the judiciary with right-wing judges. That has already happened. The Trump administration did not pursue or was not successful in pursuing its domestic agenda on any other front but judicial appointments. It completely transformed the nature of the judiciary, and the Biden administration is sort of clawing that back now, but they were incredibly successful in a very short period of time, and not just with the Supreme Court, but with the lower federal courts as well. I think we'll see more of that. I think if Congress changes hands and there is a Republican majority, a working Republican majority in Congress, there will be a nationwide ban on abortion. There will also, I think, likely be a move toward fetal personhood and the recognition of the fetus as a person. Pro-life groups have already signaled that this is exactly what they are interested in and that what they are hoping to see. This has always been the goal. And that makes sense, right? Because as much as the court in Dobbs talked about this being a state-by-state settlement, now every state gets to decide what they want to do about abortion policy. If you believe that abortion is tantamount to murder, and I believe that many in the pro-life movement genuinely believe that that is the case, you cannot be comfortable or okay with people in California being able to commit murder and people in Oklahoma not being able to. Like, there's just no daylight in that position. So the ultimate goal is fetal personhood, and that is where we will proceed.
Well, I want to pick up on what you just mentioned, which is that in the Dobbs decision, the justices in the majority argued that they were basically performing an act of democracy and that they were returning the abortion question to its rightful place. They said, quote, to the people and their elected representatives. You've argued that their apparent concern for democracy here is disingenuous. How so?
So just for those who haven't read this opinion, and I do encourage everyone to read the opinion if you can, in the Dobbs opinion, the court overrules Roe versus Wade and Planned Parenthood versus Casey on a 5-4 vote, a 6-3 vote to uphold the Mississippi law that was challenged in the first instance. But in overruling Planned Parenthood versus Casey and Roe, the court notes that the right to an abortion that Roe recognized in 1973 was unmoored from constitutional text. It's not enumerated in the text of the Constitution, and it is untethered from the history and traditions of this country. That argument, I think, has a lot of flaws and can be poked holes. We can poke holes in that for days, and we don't have to do that here. The second sort of register of argument, though, was that what Roe got wrong was not simply its misidentification of a fundamental right, but that it did so in a way that usurped the people's prerogatives to decide this question of abortion regulation for themselves through their elected representatives, and instead inserted a judicial resolution of that decision that then arrested any kind of debate that might have happened at the state level. And so the court in Dobbs says, it is not doing anything more than simply restoring this vexed and fractious issue that should have been resolved by the people to be resolved at the state level. And I do think that's disingenuous. I think it is principally an effort by the court to avoid claims of judicial imperialism, like the invocation of democracy and the values and vernacular of democracy allows the court to be a hero, right? It is not laying waste to 50 years worth of precedent and jurisprudence and being activist or imperialist. It is simply returning the people to their place in this decision-making process. But interestingly, the court's understanding of what democratic deliberation might look like once the decision on abortion is back at the state legislatures is, I think, quite thin and indeed maybe even a little anti-democratic. So, the court focuses on state legislatures as the place where this kind of democratic engagement will occur over abortion. But we all know that because of extreme gerrymandering in many of our states, state legislatures are often the least representative institutions in state government. The Dobbs majority doesn't mention anything about state judges who might interpret state constitutional provisions to protect or preserve abortion rights, nor do they mention state elected officials like governors or attorneys general who make decisions about whether to veto abortion regulation or whether or not to enforce them. There is no mention of direct democracy, which, as we know, in the post-Dobbs landscape has been a really important mechanism for preserving and in some cases expanding reproductive rights. It also doesn't take into account that democratic deliberation might proceed in multiple directions. The Dobbs majority focuses on the idea that state legislatures will continue to retard abortion rights, limit them. But true democracy might lead to the preservation or indeed the expansion of abortion rights. And that is completely undiscussed in this opinion. And then, importantly, there is this moment in the opinion where Justice Alito reminds us that American women are not without political power. It's that women are more likely to be registered to vote and in fact do vote in greater numbers than men. And so his point seems to be you have the political power, ladies, if you choose to exercise it, to do something about this. But that sort of limits our understanding of what it means to exercise political power to simply the act of voting or maybe holding office. But if you take a more fulsome understanding of political power, the portrait looks decidedly different, right? So in the United States, although women are registered to vote and do vote in higher numbers than men, they are a minority of elected officials. They are grossly underrepresented in Congress and in state legislatures. They are grossly underrepresented in terms of mayoral positions throughout the country. They are grossly underrepresented in terms of federal and state judgeships. They are grossly underrepresented in terms of state level executives. In terms of the ecosystem that surrounds politics, women are a minority of lobbyists, both at the federal level and at the state level. And they contribute to political campaigns at much lower levels and in smaller amounts than do men. So if you take a broader view of what political power means and who exercises it, it is not the case that women have the most political power in the United States. And again, the decision really doesn't focus on that. And then finally, the methodology that the court deploys for this sort of pro-democracy understanding of what it is doing is fundamentally anti-democratic. Like this history and tradition, originalism logic prioritizes moments of constitutional interpretation that occurred at a time when we can generously describe the United States as in the throes of a democratic deficit, right? These are moments in time where women and people of color were not considered part of the polity, were not part of the decision-making process. And we are prioritizing the deliberation of laws, older abortion laws that were passed at a time in which women couldn't vote and people of color were less likely to be able to vote. So this is the kind of democratic deliberation that the Dobbs majority seeks to vindicate through this method of interpretation that is absolutely wedded to the past and insists that our rights be understood through the lens of past generations.
I was going to ask you about what role ballot measures should play in the future and in reproductive rights activist efforts to resecure these rights, because as we know, all 7 that have been put to voters since the Dobbs decision have passed, most recently in Ohio. But also in Ohio, the GOP, the state GOP, is claiming without evidence that there was foreign election interference, and that's why voters voted for abortion rights, and that they might just try to prevent the courts from actually being able to allow it to take effect. So I guess given that and the limits to democratic participation that you outlined through things like gerrymandering, and the fact that voting is only one form of political power, are ballot measures the way forward to resecure these rights, or are they inadequate given those factors?
So yes and no to ballot initiatives. I think when you look at the success of ballot initiatives post-Dobbs, you see the point about representative government. Like when the people have an opportunity to directly register their preferences at the ballot box through voter referenda or initiatives, they vote overwhelmingly to preserve or expand access to reproductive freedom. And that makes clear, like when you are doing this through representative government, your vote is mediated through your representative, who may be beholden to an entirely different constituency because of gerrymandering, right? So yes, in that sense, there's a lot of promise in ballot initiatives and referenda. But importantly, most states do not have the mechanisms for direct democracy. So there's that. Like this isn't a magic bullet because it doesn't exist in most states. Interestingly, in many of the states where it does exist, we are seeing efforts to limit its use in this post-Dobbs landscape. So, you've mentioned Ohio, where the Ohio legislature is like, I'm surprised by all this democracy. All of this democracy looks very anti-democratic to us. We would like to make it less democratic and not count this democratic vote. In Mississippi, the Mississippi Supreme Court in 2000 eliminated the state's voter referenda system, and it's now being discussed as being reinstated, but with a really important caveat. Mississippi is not going to allow voter referenda or initiatives to be used for questions of quote unquote constitutional rights, which would include abortion and reproductive freedom. So you will have the ballot initiative there, I think it is likely, but it won't be able to be used for that. So again, and we're seeing assaults on ballot initiatives. There was one in Ohio, an effort to raise the threshold for using a ballot initiative to amend the Ohio Constitution because they understood that this voter initiative in November was likely to be successful to enshrine reproductive freedom in the Ohio state constitution. So, that I think is an important sort of caveat to all of this. It's also worth remembering that this sort of new progressive posture of direct democracy is a pretty new development, because historically, direct democracy has actually been used to further conservative causes and backlash to progressive ends. So, in the 1920s in Oregon, there was a voter initiative that basically forced parents to send their children to public school because they were trying to limit the authority and power of a rising Catholic and immigrant population in the state. And among those championing that ballot initiative was the Ku Klux Klan. And it passed. And it took the Supreme Court in 1925 to strike down that ballot initiative. In California, anti-affirmative action policies were enshrined in the state constitution through voter referenda. Following the California Supreme Court's decision to allow same-sex marriages in that state in 2008, we had a voter referendum, Proposition 8, that invalidated that decision and eliminated access to same-sex marriage. So again, I take direct democracy with a grain of salt. Like often it has been a means for majorities to actually limit minority rights in really important ways. So like this is sort of, a kind of glimmer of hope for direct democracy, but as quickly as it came, it could also be eliminated.
Justice Clarence Thomas has, I'm sorry, I see that caused a shudder, has written in multiple opinions that abortion and contraception can be used for eugenicist aims. He argues specifically that they could be used to reduce the Black population. But you have written that this concern is based on a misreading of history and incomplete history, in part because it totally overlooks the history of state-sponsored forced sterilization, which has disproportionately harmed Black, Brown, and Native women, especially those who are poor and disabled. This endures today, as I mentioned, and I have the article here. The New York Times just did, if I can get it up, the New York Times just did an investigation that showed that this persists throughout Europe, and that disabled women are being forcibly sterilized. I'm sure many of us remember the headline from 2020 where Dawn Wooten, the whistleblowing nurse at the ICE detention facility in Georgia, alleged that immigrant women there were undergoing mass hysterectomies. That sparked a congressional investigation, which found that they were undergoing at the very least, unnecessary gynecological procedures, sometimes without their consent. But despite all of this, you have written, or as you've written, I should say, coercive and forced sterilization has not been a focus of the campaign to secure reproductive rights. Why is that? And how should activists make it a focus going forward?
Well, so first, can I just debunk Clarence Thomas? Okay.
Please do.
So Justice Thomas has been shepherding this abortion is eugenics argument for some time now. And it's actually really interesting. Justice Thomas actually talks about race maybe more than anyone else on the court, even as I think his views on sort of racial politics are out of step with many minority communities. But he often inserts racial dynamics and racial narratives into issues where the racial valence is really not obvious. And so I think it's interesting. And I think one of the reasons why he was able to do it so successfully is for a very long time, he was the only African-American on the court, and there was really no one else to counteract those narratives. Now there is, and so maybe this will be of limited success going forward. But in a decision on the shadow docket in 2019 called Box versus Planned Parenthood of Indiana and Kentucky, the court was faced with a challenge to two Indiana laws, one that required the funereal disposal of fetal remains, another that was basically a trait selection law that said that abortion could not be used for purposes of race or sex selection. They're known as reason bans. And the court dismissed the funereal disposal requirement very easily, upheld that as a health regulation, but said that it was not going to grant certiorari as to the other case, the reason ban, the other law. And Justice Thomas wrote a concurrence in which he agreed with the court, like no need to grant certiorari on this, but he said, the time is coming when you will not be able to so easily put off the question of whether or not restrictions on abortion are merely the state's modest attempt to limit abortion's eugenic potential. And then he sort of wove this history in which he conflated Margaret Sanger and the history of the birth control movement, the contraceptive movement in the United States, with the history of eugenics. And he said that Margaret Sanger wrote hand in glove with the eugenics and cited birth control clinics in Harlem and in other minority enclaves in an effort to limit Black reproduction. And some of this is true. Most of it is not. I will note Justice Thomas has a law degree. He is not trained as an historian. In fact, no one on the Supreme Court is trained as an historian. But although there are some slivers of truth in that, there are also big gaps in that historical narrative. One, Margaret Sanger was not an abortionist, and she was not interested in abortion. She actually believed that if there were wide access to contraception, you would not need surgical interventions like abortions, which is very against abortion. She did work hand in glove with the eugenicists, which at the time were very interested in contraception, but not very interested in abortion. The eugenics movement's principal aims around reproductive freedom focused on expanding contraception, expanding sterilization, and expanding immigration laws to prevent the introduction of quote unquote foreign or base elements from other countries into the United States. That's how the eugenics movement worked. It had nothing to do with abortion. Justice Thomas leaves all of this out. He also leaves out the fact that when Margaret Sanger did go to Harlem to cite her birth control clinic, she did so at the invitation of W.E.B. Du Bois, who at the start of the Great Migration recognized that African-American families, which had been large in the South because of their agrarian purposes, would not be able to be successful in the North in an industrial environment because they were too big. And so he believed that access to contraception was absolutely central to the fortunes of the Black community. Later in the 1960s, a lot of other groups sort of picked up on this kind of notion of access to reproductive freedom as tantamount to genocide, especially when the state was involved. The Black Panthers talked about this in these terms. The Nation of Islam also talked about it in these terms. And interestingly, this kind of created a schism within the Black Panthers between the men of the Black Panther movement and the women, where the men were very much against government-sponsored reproductive quote unquote freedom, like access to contraception or access to abortion. They said that this was an attempt to limit Black power. But the women within the Black Power movement were like, wait a minute, fellas, we want to be a part of this movement too. And we can't do it if we're at home taking care of your children, if we don't have control over reproduction. If you really want to talk about genocide, these women like Toni Cade Bambara, Angela Davis, Florence Kelly, if you really want to talk about genocide, they said, why don't you focus on the forced sterilization of poor Black women in the South that is going on under the cover of state law right now? And that was the case. Like, as access to public assistance expanded in the South and more Black women joined the roles of those on public assistance, they were forced to become sterilized in order to have access to those continued benefits. So again, all of this is left out of this narrative that abortion is genocide. And to be very clear, Justice Thomas has been absolutely amazing in seeding this narrative and having it flourish in lower federal courts around the country. In a set of cases from the Sixth Circuit on a reason ban challenge, there were 5 different concurrences and 1 majority opinion. Every one of those opinions noted that abortion could function as a form of eugenics. And it's also in the Dobbs opinion. In footnote 41 of Dobbs, Justice Alito talks about this notion that those who seek liberal access to abortion have done so for the purpose of limiting African-American reproduction. So, why don't we talk about the other side of this coin, sterilization? I think largely because it has impacted disproportionately poor minority women, Black women in the South, Latino women in the West, Indigenous women across the country. The Indian Health Services has been one of the largest perpetrators of compulsory sterilization in this country. We don't talk about that at all. And largely because it's been borne by minority communities, which is not to say that women who are not minorities have been left out of this. It's just a different kind of pronatalist message, right? So there was a period in the United States where if a white woman sought surgical sterilization, she would first have to seek approval from a board of physicians at the hospital, and then they would determine, 1, based on her age, 2, based on the number of children she already had, and 3, whether or not her family was complete, as they understood it, whether she would be eligible for the sterilization. And so it's, for one group of women, we want them not to procreate. For another group of women, we are concerned if they don't procreate, right? And this proceeds on a very racialized basis.
And I mean, there's been many headlines even since Dobbs that young people who know that they don't want to have children eventually and are worried about being in this position now where there's not the federally established right to abortion, go and seek voluntary sterilization, and their doctors will refuse to do it because
this is happening with men with vasectomies. So a number of Planned Parenthood affiliates, including Planned Parenthood of Tennessee and Northern Mississippi, now that they are prohibited from performing abortions, they are offering vasectomy services to men. And if the patient seeking a vasectomy is below a certain age, they have to have basically informed consent about it, in much the same way women had to have informed consent in order to get an abortion before Dobbs. So again, really interesting, like this idea, who should be procreating.
Right. And these issues that we're talking about that, that are typically left out of these discussions, I think kind of point to the ways that this discourse is still really reproductive rights focused rather than being reproductive justice focused. Can you, and we, activists are raising reproductive justice related concerns, pointing out how abortion bans also lead to higher maternal mortality. We already have the highest maternal mortality rate of all wealthy nations. Black women are 3 times more likely to die from pregnancy related complications than white women. Abortion bans also lead to poor health outcomes for pregnant people and children. So despite all of this, I mean, why do we still not sort of take a reproductive justice focused approach to lawmaking? What kind of policies would we have to put in place to be concerned with to basically be concerned with people's health and well-being beyond the moment of pregnancy or abortion?
I don't know why we aren't thinking more expansively. I think some of this is the siloed interests of interest groups is part of it. I think we are slowly becoming aware of the fact that our fates are intertwined, that an assault on one group's rights necessarily implicates another group's. And we actually have to be concerned about the marginalization of any group because the next group could be us. And we have to think about it in those terms. I'm reminded of some of the work that happened in Mississippi before Dobbs. In Mississippi, there were 2 laws that were on the floor of the Mississippi legislature that were in danger of being passed. One was a voter suppression law. One was an abortion regulation that would have been incredibly restrictive. Women's rights groups flooded the state and came out to object to and to beat down that abortion law. African-American civil rights groups and voting rights groups were focused on the voting rights law and asked for help from the women's rights community. Like these things are related. We need to work together. The women's rights groups were really focused on abortion. Like we're about abortion. We're not about voting rights. And I think that was really short-sighted because the two are inextricably intertwined. You don't get a law like HB 1510, which was the law that was upheld in Dobbs, unless you are able to suppress the number of voters turning out in an election, and unless you can gerrymander the state so completely that voters cannot actually register their real preferences to their elected representatives. These things go hand in hand, and for too long, we have seen them as siloed, and we viewed our particular interests as just that, ours, and unrelated to anything else that is going on. What Justice Thomas did with this abortion is genocide narrative is to divide different parts of the social justice community, divide the Black community from the disability community, from the women's rights community. That's the point. That's the goal, because if we are divided, we cannot work together. And so we're in this moment, not just around reproductive rights, but around everything, a moment of incredible division. That division is how authoritarianism happens. Like, we have to understand our shared fates constantly, because if we don't, those fissures are the opening doors that allow authoritarianism to walk through.
There's one kind of division that Republicans are not very interested in, which is divorce.
Very good segue.
Yes,
Julianne.
thank you. You set it up for me. I am just going to shamelessly promote Mother Jones' story, great story by my colleague, Katie Hirschenroder, who's here. And I actually was not aware of this push until I read her story. And I've seen a lot of coverage since. There is this under the radar push on the right.
Not under the radar anymore.
Okay, well, maybe thanks to Katie. Thank you, Katie. Republicans in Texas, Nebraska, Louisiana, and Mississippi have either openly opposed no-fault divorce, debated eliminating it, or sought to weaken it. New House Speaker Mike Johnson has supported eliminating no-fault divorce for decades. So this means, they don't want you to be able to just end a marriage, basically. They want it to be a lot harder. And I just want to quote a line from Katie's piece that shows the overlap of this issue with abortion access. She wrote, "Just as abortion access seemed settled law and discussions of ending Roe were seen by some as a pipe dream discussed to fire up the base, the potential death of no-fault divorce sounds antiquated and is decidedly real." How real is it? How widely do you think we'll see this push go? And do these two pushes share a goal?
So first of all, who knows what no-fault divorce is? Nobody. Great. So adults know. College students, okay, you don't know a world without no-fault divorce. That's why you don't know what it is. Like, it's all you know of divorce. So before the 1960s, like late 1960s, if you wanted a divorce in the United States, you had to show fault, right? You had to show that one party was at fault, like adultery, cruelty, abandonment, whatever. In the 1960s, California pioneered the no-fault divorce revolution, where if you wanted a divorce, you could just get one. You could just leave. And all you had to show is that, like, there were irreconcilable differences or incurable insanity. And most people just stuck with irreconcilable differences. And it spread throughout the country, right? And because there were a lot of unhappy people, and unless you could show that one party was faulty and the other party was innocent, you couldn't get out of divorce. Like, if you both cheated on each other, you had to stay with each other because you were both too faulty to get divorced, right? So incredibly unhappy situation. No-fault divorce kind of revolutionized it. And more importantly, it revolutionized it at a moment where the women's rights movement was rising, right? And so for a lot of women trapped in unhappy marriages, because they didn't have access to education, they didn't have access to employment, they had to stay with their husbands, the opportunity to leave an abusive or just an unhappy marriage opened a lot of doors. And it helped spark a revolution in a lot of ways. And it changed the nature of marriage, right? More of a partnership, less of like shackling to an albatross, right? This was a really big deal. And it's not surprising then, given how much it transformed family life, expectations of family life, expectations of equality within the family. It's not surprising then that it would be high on the list of for backlash in a world or a country that is moving toward a more authoritarian model. I mean, if limits on women's rights is part and parcel of authoritarianism, of course, no-fault divorce is going to be on the list, right there with limiting access to abortion, limiting access to contraception. And yes, limits on contraception are coming. All of that is coming. So it's not a surprise, right? This has been an avenue for women's liberation. To be very, and to be fair on both sides, it has also been an avenue for women's impoverishment. I mean, like, you know, divorce without greater access to economic freedom and economic mobility and capital is a disaster, right? So all of this is sort of about keeping women attached to men and keeping them within the home and their role within the family.
Just checking, I got a signal, but how long before the Q&A? Okay, so there will be an audience Q&A, so start thinking of your questions if you have them for Professor Murray. Let's talk about the intersection of reproductive rights and LGBTQ rights, because we're seeing concurrent attacks on both of those fronts. Obviously, in the US, record number of anti-LGBTQ bills have been introduced across the country over the last few years. Clarence Thomas also wrote in the Dobbs, in his Dobbs decision that Lawrence versus Texas and Obergefell versus Hodges, the decisions that legalize same-sex sex and marriage, should be revisited going forward. He, of course, left out Loving versus Virginia, which would nullify his own marriage. That was the case that allowed for interracial marriage. So definitely another example of selective history. In Italy, Prime Minister Giorgia Meloni has been accused of attacking LGBTQ couples by allowing only the biological parent to be formally recognized on birth certificates. She's also said that she would like to limit abortions. In Russia, I'm sure many people saw the Supreme Court just this past weekend outlawed what it called an international LGBT public movement. And they're also restricting contraception access, abortion access. So how are these two rights linked in the law? And as we see abortion rights erode, will we continue to see LGBTQ rights erode?
I think one way to understand all of these different rights is that they disrupt settled sex stereotypes, right? Abortion disrupts the sex stereotype that women are mothers and only mothers. Contraception disrupts the sex stereotype that women are mothers. Same-sex marriage disrupts the stereotypes that there are specific gender roles within the family that can only be played by either sex, right? If you think about it in those terms, it's not surprising that these things are linked, right? Phyllis Schlafly, who defeated the ERA, did so by saying the Equal Rights Amendment in the 1970s would lead to abortion on demand, homosexual marriage, and the end of family life as we know it. She also talked about no-fault divorce, right? Like, and you know, women, if you want to keep your protections like alimony and a husband, you should oppose the ERA. I mean, so don't for a minute think that this is disconnected. Like, it is a clear, coordinated attack on a specific set of gender roles that has existed for a very long time in our country, that in the last 100 years have begun to be unsettled in a lot of ways. And you all are the evidence of that. I mean, if you look at this room is more than 50% women. That wouldn't have been the case 2 generations ago, when college and higher education would have been deemed irrelevant for women unless you just wanted to be a really well-educated mother. There was no need to educate your daughters. Right? So there has been a sea change in this country, and it just goes back to, like, you know, make America great again, a time when most men did not face competition in the workforce, in school, in public life, where their dominion and their authority was unquestioned. So all of this is part of it. I also think the attack on marriage or same-sex marriage, I'm not sure that we're going to see attacks on Obergefell and gay marriage right away. I do think we're already seeing attacks on LGBTQ identity, right? So last term, the Supreme Court decided a case called 303 Creative that essentially allows individuals to discriminate against LGBTQ persons on the basis of free speech. Like, that if you are required to comply with an anti-discrimination law that says you cannot discriminate on the basis of sexual orientation, that is tantamount to compelled speech, the state making you speak a pro-LGBTQ message, with which you object. That's the first step, right? You normalize different treatment. And then in 50 years, you could eliminate same-sex marriage. Or maybe you don't want to, because another thing that marriage has done in this country that we should be very forthright about is marriage is a system of social provision. There's a reason why there has been such an effort to get everyone married, because we don't have a social welfare state. We don't have a social safety net. Like, if you get sick, your family should take care of you. If you need elder care, you rely on your daughter or your daughter-in-law. I mean, this is real stuff happening right now. You need childcare. You either pay for it yourself or your mom moves in with you and helps you out with that. And a lot of this has been borne by women in families. So, one way to understand all of these challenges is that the assault on LGBTQ rights, the conservative interest in same-sex marriage, even as they denigrate other LGBTQ rights, the disdain for abortion and reproductive freedom is nested in a neoliberal ethos that depends on the family to accommodate the dependency of all individuals in society, because we do not have a government that provides for that, or does so only limitedly and sparingly.
Wow. Do we have to move to questions, or do we have time for questions? Okay. So now's your chance. Burning questions about all these fun topics. Please take advantage of this opportunity.
Oh my God, am I first? Hi. Oh man, thank you.
I have that effect. I'm sorry.
So much to say. I'm thinking about domestic violence. I'm thinking about the fact that women are often abused at a higher rate during pregnancy, as well as intimate partner violence, once you have children, it's harder to actually leave your partner than it is to stay with them due to threats for your physical safety and that of your children. Have you seen an increase in these stats and what has been reported in terms of intimate partner violence, of women not leaving their partners, of women seeking help? Do you think that we're going to see a spike over the course of the next 5 years? Do you see that on the horizon?
So I think the data is like that kind of data isn't available because the issue is still relatively new, but everything suggests all of the things that you say, that you are more likely to be susceptible to domestic violence in pregnancy, just for a lot of different reasons. This week, I've been thinking a lot about Justice O'Connor and her legacy at the court. And I just keep coming back to, Justice O'Connor was part of the 3-justice plurality that essentially salvaged Roe versus Wade, not completely, but upheld the right to an abortion acknowledged in Roe and gave the state wider latitude to regulate abortion. But in the Casey decision, there were several different provisions of Pennsylvania's abortion law at issue. One of them was a provision that required anyone seeking an abortion, any married woman seeking an abortion, to first notify her husband. And in the Casey opinion, although it's unsigned, it's very clear. It's Sandra Day O'Connor writing. She talks about how a provision like that could really imperil women who are in abusive, intimate partnerships. And more importantly, she notes, it is essentially hearkening back to the days when women were legally the appendages of their husbands. They had no legal identity of their own. And so, she invalidated it and struck it down. What most people don't realize is that the Casey case proceeded to the Supreme Court from the Third Circuit, which is the intermediate appellate court that includes, among other states, Pennsylvania. And one of the judges who was on the panel that heard the Casey case before it went up to the Supreme Court was a young, enterprising judge named Samuel Alito, who voted to uphold the spousal notification provision, and who in 2005 was selected to fill the seat that Sandra Day O'Connor vacated, and who in 2022 drafted the majority opinion to overrule Casey.
Mic drop. Mic drop.
Coincidences.
Yes. Other questions?
We have some of the questions in the Zoom right now. We could read one. So the person says, I'm not sure things have changed since, but in 2022, nearly all of the states with abortion bans do not make exception for rape or incest cases, with only 4 allowing one with a police report. And what the person is asking is, how do the absence of exceptions for rape or incest in abortion bans specifically influence the safety and options available to survivors of sexual assault, as well as the legal and ethical implications of such restrictions?
So a number of states have passed more draconian abortion bans in the wake of Dobbs, with fewer opportunities for exceptions, and even for rape or incest. And obviously that compounds the violence and trauma of those experienced for those who have survived incest or sexual assault. In circumstances where there are health exceptions, I don't want to minimize this. It's really important for there to be exceptions for the basis of exigent health circumstances. But these laws are often written by legislators, maybe lawyers, definitely not doctors. And it's really, they don't provide enough guidance to physicians so that they understand where they can legitimately use their medical expertise to provide an abortion. And so, and I think that's by design, right? To really chill doctors from being able to perform this procedure. And right now there's litigation in Texas, the Zorowski case. If you Google this, we talk about it on Strict Scrutiny a lot. They're basically suing the state of Texas to provide more guidance to physicians about what circumstances are sufficiently exigent so that physicians can lawfully provide an abortion, because women are bleeding out in parking lots. Women are waiting and becoming septic in order to qualify for an abortion. There's just not a lot of guidance at all. And interestingly, a lot of the campaign against what we're seeing is being led by physicians who are like, I can't practice I don't know where my judgment ends and the law begins. And that is exactly what happened in the period before Roe, where the campaign to liberalize abortion laws in the 1950s and 1960s did not come from feminists at first. It came from physicians who could not figure out how to lawfully do their jobs.
I mean, you've also talked about how confusion is part of the strategy,
Yes.
right?
Yes.
And there was a great article in the Washington Post by Caroline Kitchener on this very topic, on how hospitals are not oftentimes issuing clear and specific guidance to physicians in states with bans or restrictions on when they can actually intervene because they're afraid of getting sued. And so this just furthers the amount of situations in which physicians feel hamstrung and people are.
And this is physicians in states that have more liberal policies, because people are coming over the borders. And, the question is, like, can you be extradited? Unclear. Can the exercise of your medical judgment in California make you a target for liability in Arizona or Idaho? Like, it's all very unclear. And again, that kind of confusion is exactly the environment in which conduct is chilled.
Yeah. There's someone do we have a mic? I think.
Hi.
Third row. Yeah.
Hi, I wanted to talk about your spillover, like fetal personhood argument. So in the policy debate community, we love to say that spillover won't happen. It's like an act of fear mongering and is meant to stifle legislation, for example, personhood to plants, animals, etc. So based on your expertise, I wanted to pose the 2021 and 2022 cross-examination debate resolution, which was, should we extend legal personhood to AI nature and non-human species? And if your answer is yes, how will that affect fetal personhood and spillover? Because
You sound just like my daughter, who's a policy debater. I hate these.
I am too, yeah.
I hate these. Like, it was like at Thanksgiving, resolved. I'm like, no, we're not resolving anything. Like, no, I refuse to answer this question. Okay, so the fetal personhood spillover, I don't know that those who are in favor of fetal personhood are thinking about how this extends to AI or to animal life or whatever. It sort of leads to, although the logic of it certainly could.
Mhm.
I think right now at sort of time one, the very short-term goal is to enfranchise the fetus as a constitutional entity with rights that must be balanced against the rights of other constitutional entities, the pregnant people. I think one of the ways we know this is afoot is because, one, the pro-life movement has told us explicitly that this is what they're doing. I also think there are clues in the Dobbs opinion. So it's not mere fear mongering. I mean, I think if you read the tea leaves, it all kind of shakes out. In Dobbs, they refer to the fetus as a human being. They note that a number of government entities and individuals and constituencies regard the fetus as an unborn human being. I think one of the reasons why Justice Alito is at great pains to sequester the abortion question from other substantive due process rights like same-sex marriage, interracial marriage, same-sex sex, all of these other decisions that have been validated under theory of substantive due process is because if you were to proceed to enfranchise the fetus as a constitutional entity, you would do so under the substantive due process clause of the 14th Amendment. So, interestingly, it is Justice Thomas in his concurrence who's like, get rid of all of them. Substantive due process doesn't exist. And the majority is like, not so fast. We might need that. We might need that for later. And I think that's why. There are a couple of cases that also point to this burgeoning interest in the fetus as a person. So there is a case that's being brought in Texas. You probably heard of it. It was wildly discussed last summer, but a gentleman who is estranged from his wife is suing his wife's friends and a woman who procured medication abortion pills for his wife to terminate her pregnancy. And it's not being prosecuted under SB 8, Texas's, bounty hunter abortion law. It's just being prosecuted as a standard. It's not being prosecuted. It's being brought as a standard tort claim in wrongful death. Why is that meaningful? Because wrongful death claims are basically negligence claims where someone has negligently caused the death of a person. Here, the person who has negligently been caused to die is the fetus. And so that's a backdoor way into fetal personhood. So resolved, it's coming. Okay.
I had a question about in legal terms. Do you consider the problem, or rather the question about reproduction rights, more of a matter which should be concerned with the judiciary or that with the legislative instead? And why I'm asking this very question is because just like in Roe versus Wade, the US judiciary overturned the decisions. But in the recent time in India, in October, the Supreme Court basically said in a judgment, which was referring to the LGBTQ rights and whether they can have rights for adoption, that it's not a matter to be debated in the judiciary, but rather in legislative, because it depends on the consensus of the people and then, of course, the members of parliament. So is it a is it a matter to be dealt in the judiciary, or is it a matter to be dealt in the legislative hemisphere?
Well, I think the Dobbs decision stands for the view that this is a decision that should be dealt with legislatively, that the people should have their say acting through the representative governments. My rejoinder to that would be, there are some rights that are so fundamental to the person that they cannot be left to debate by the majority, right? Like equality, personhood, like, are those things that we necessarily leave to the political process for majorities to tell us who we are? And again, it really just depends on how you understand this. Like, some people are like, abortion is just about regulation of a medical procedure. I am of the view that access to abortion, contraception fundamentally goes to a question of personhood. And that's likely because I am a mother, and I chose to be a mother. And I can't imagine having that choice thrust upon me by the state, not because I don't love being a mother, but because I understand how fundamentally becoming a mother changed my life. It expanded my world in ways both profound and banal. It also limited my ambition for myself in really profound ways, because I had to think about what my role would be and how would it impact my children. To say that that aspect of identity is something that is formed under the compulsion of the state, to me, is to deny how fundamentally it affects a woman's life to become a mother. And I think you could say the same thing about same-sex marriage. The decision of whether and with whom to partner is so fundamental to how you understand yourself, how you proceed in the world, that the choice of a partner is not something that should be left to the state to determine for you. These are not the kinds of decisions that should be voted on. Like, I would never want to vote on whether someone here was a person, in much the same way I would never want someone to vote on whether or not I could make a decision about what kind of person and what kind of life I would have. And so I think it really just depends on how you view this, and we can differ on that. I think we have differed over time, but the whole point of a constitution and the protection of these rights that are viewed as fundamental is that there are certain rights that are so important, so constitutive of the person, that they shouldn't be up for debate.
Thank you. Another questions we have in the Zoom right now. Ronald is wondering whether or not blanket abortion bans violate a woman's right to due process, and that any ban constitutionally requires an individual hearing as to the medical condition and necessity for an abortion with respect to each woman, and that a due process hearing should be initiated by the state and not the woman.
Right. So Ronald is basically talking about a procedural due process argument in favor of abortion. I think this is essentially what the Zarowski case is trying to get at. Like, what are the procedures by which you determine whether an abortion is permissible or required because of exigent circumstances? And the point of the matter is we just don't know. And we don't know what the procedural rights of pregnant people are because this court has decided as a matter of substantive due process that no fundamental right to this exists. The court also, I think, gives short shrift to the notion that there's an equal protection right that would protect a right to abortion. Again, I go back to this question of like, the imposition of motherhood has often been used as a means of keeping women out of public life. And so abortion restrictions, any restrictions that sort of turn on physical or biological differences that distinguish men from women traditionally goes to this question of equality. It's the imposition of a sex role, a sex stereotype, and for that reason should be subjected to the kind of intermediate scrutiny that sex-based classifications have traditionally been subject to.
Hi, I'm over here.
I think she was going to go. I'm sorry.
Oh.
Sorry.
Okay, thank you. So at the top of the presentation, you mentioned the recent election of Javier Milei in Argentina. And I know that when they were passing Argentina's like more liberal abortion laws, Pope Francis was among like many Catholic advocates who like spoke out against it. So I was curious, to what extent you think religion is merely a cover for the anti-abortion movement, if there's a deeper reason, or if the like global turn against abortion rights is a religious movement like in its entirety?
You know, I think religion is a part of it. It doesn't explain all of it. I mean, you know, religion can also be a tremendous force for imposing particular sex roles in a society. And so, you know, to that extent, yes, of course, religion can play a role in this. I would also, though, point to Ireland, where the liberalization of abortion laws were led by women who were very active in the church, who argued that allowing a young woman to die because she was ineligible for a life-saving abortion violated the laws of God and man, right? So, I mean, there are lots of different ways in which this can play out. There are a number of individuals who are arguing that as a matter of Talmudic law, if you are faced with a situation where there is a conflict between the life of the pregnant person and the fetus, you must prioritize the pregnant person. Like the Talmud requires that. And so, like, religion is part of this story, but it could also lead in other directions as well. And so, you know, I think one of the questions that we're seeing here is sort of, how does religion get marshaled here? Whose religion? Are we going to be ecumenical about the faith traditions that we call upon, both to limit reproductive freedom and to expand it?
Dean Mostov gets the last. Oh, okay.
Sorry about that. I just remember an episode of Strict Scrutiny that highlighted, yeah, I'm a fan of the podcast, that highlighted the efforts of the Kansas voters to embed abortion access in their state constitution. And I'm also a California voter. I voted to also embed abortion access in the California state constitution. And I was wondering if there's any limits to such protection, or even if that protection is genuinely protective.
So we're going to find out, right? We're going to find out in all of these places where direct democracy has been used to either preserve or expand reproductive freedom. Some of these initiatives may go up to state Supreme Courts, right? And unclear how they might fare there. Like, you know, courts get to interpret constitutional provisions, and, you know, they can interpret them in ways that appear to us consistent with the will of the voters, or more limitedly. So I think we're going to see what all of that looks like. You know, and I'm cognizant of, I've been incredibly depressing in the last hour and a half. So I want to end on a hopeful note. You raise a really important point, right? It's not enough just to go to the ballot box one time because there was an issue that bestirred you, right? This entire thing did not happen overnight. It took 50 years, right? It took 50 years for this to happen. And it happened piecemeal because we looked the other way, because we assumed that someone else was handling that. That was someone else's fight. If this is going to be reversed, if we're going to stop this rising threat of authoritarianism, I'm going to be very direct with you. I think we are actually in the throes of a constitutional crisis. I think we are watching an ascendant authoritarianism in this country. If we are going to deal with that, it's got to be all hands on deck. And, you know, I speak to the young people here. I get it. Like, when you go to the ballot box and what you wanted to have happen didn't happen, whether it was student loan relief or something else, it's incredibly discouraging. They're counting on you to be discouraged, to not go back, to be like, I didn't get student loan relief. I'm done. I'm out. If we're going to turn this back, you've got to pack a lunch and get hydrated and limber up, because this is a 50-year fight. When Black people were trying to vote in the South, it wasn't a one and done thing, and they understood this. You boycotted the bus, and then you went to try and vote, and you were turned away, and you went back, and you kept going back. You have to be in it for the long haul. They're in it for the long haul. And I'm telling you, the long haul is going to be a lot longer under authoritarianism. So I get it. And sometimes being in it for the long haul means recognizing the difference between pragmatism and idealism. And that's hard. That is hard. Recognizing that good enough might just have to do, even though you dream and hope for something better. We're in this moment because people dreamed big and it worked. And this is the backlash to that working. So if you want to dream big again, we all have to be in it. We all have to understand how deeply and inextricably intertwined our fates are, that we have way more in common than what divides us, and that we all have agency to do something about it. And we literally have to exercise it every time. Leave no power on the table. It's not about just voting for president. It's about voting in every single election in which someone is running for something and has the power to do something. Leave no power on the table. Every time you do not go to the ballot box, someone else is going to register a preference that is probably not yours. So all of this is not irrevocable, but it's not instantaneous either. It requires consistent and sustained work. You are NYU students, you are NYU graduates, members of this community, you are up to this task. You've been trained by the best, you know the stakes, and you have the powers of persuasion to tell other people what is at stake here and how they too can be a part of a movement toward better. So do that. Every single one of you can and should do that. Lead.
Hopeful note to end on. I think we are wrapping up, correct? Okay. Thank you so much, Professor Murray, for everything that you have done to encourage public understanding on these issues over the years, and for lighting the path forward. It was so great to be here tonight, and thank you to all of you for coming. Dean Mostov is going to close us out.
Let's hear it again for Julianne, who did a great job. Fantastic work, great questions. And Professor Murray, who is I hope that will galvanize everyone here. We cannot be divided. It leads to authoritarianism, to the loss of democracy, and the loss of all of our rights. So let's hear it again for this incredibly encouraging, while very depressing message. I want to thank all of you for coming, but particularly I want to thank our team, the Liberal Studies team led by Simmons Jendai, Gabriela Musk, Isabella Rivera, and all of our student leaders. Thank you, thank you, thank you. To our partners, the Office of Global Inclusion and Strategic Innovation, the Birnbaum Women's Leadership Center, the president, what is it? The Presidential Women's Leadership Forum. I just want to make sure I got that right. There's probably still some food, am I right? There's a little bit left. Go get some, and everybody get ready to work. Thank you.